Welcome back to the Friday Five for October 6th, 2023. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And we're going to look at 5 quick questions this week, FAQ style, about 5 minutes long. Some questions that came up this week that maybe you've wondered about in the past and are looking for just a quick answer. Question number 1 this week: can I just throw away bills I receive at my business? So I have a client who gets a lot of bills. He runs a business. Lots of things come in, whether by email, whether by mail. Sometimes they even come in on faxes. And a lot of times he just hands the bills off to somebody, or if he doesn't really recognize it, he's had a tendency to throw them away in the past. So the way this can come back to bite you is the way it came back to bite him. And that is one of those people who was sending a bill. Even though he doesn't use their services, they sent a bill repeatedly, he ignored them, and then they sued him for what's called an account stated. And so for an account stated, part of the cause of action requires that they send you a bill and you don't actually object to it. So I had to have a little conversation with my client about, don't just throw out those bills, either send an email back or send a letter back or send some kind of notice that it's an improper bill or you're not going to pay it or you don't use their services. But simply ignoring bills can leave you open to an account stated cause of action. Question number 2 this week: do I need to put my business into a trust when I form it? In this case, I had a very nice conversation with a woman who's setting up her business, and we're doing some work to get everything set up with the operating agreement of an LLC. And she had read some blogs and actually seen a couple of my videos about using a trust as part of owning your business interest in your LLC. And she wanted to know if she had to do it right away when she set up the business, or is it something she could do down the road as the business grew? And so the upside to this strategy is, of course, there is no time limit when you have to do it. And you can't do it after you're dead, but as long as you're alive, you can set up a trust and you could then move your business interest into that trust. It does not have to be done day one of your business. And so part of our plan we created was, let's work on some other pieces of the business, focus on some growth and some other things we want to do, and then we'll circle back around to the issue of whether it's going to make sense to put the business interest in a trust at some point. Question 3 this week: do I have to personally guarantee a business contract? So the short answer is no, you don't. And if it's a business debt, it's often better if you don't personally guarantee it, because if the business can't make those payments, then your personal assets are not going to be on the hook. You're not going to be liable for guaranteeing that contract for the business. Now, the reality is, if you've just opened your business, it doesn't have any credit history, it doesn't have a P&L statement, no history of operating and the money that comes in and goes out, then a lender will likely not allow you to just get a loan in the name of the business, or if they do, it's going to be at terms that are really not favorable to your business. So in order to secure the lender and to secure your obligation, they will often ask you for a personal guarantee. If you're a business just opening up and you're taking on your first office space or your first commercial space, you will likely see your landlord will want a personal guarantee on that lease, because if the business fails, they don't want to be left holding the bag. Question 4 this week: should I sign my estate plan if I plan to move in a few years? This is a common question I get because people move all the time. And if you know you're going to be moving in an upcoming period of time, you want to look at how soon is that going to be. So in this case, the client's moving in probably 2 to 3 years. It'll be a job-related move, but then may come back to Minnesota after another couple of years. So the question was, after we put all our time and effort into creating this Minnesota-based estate plan, should they sign it or should they just wait a couple of years till they move? And the answer is you should sign it. You want to have that estate plan in place. You want all those documents in place to protect you and your legacy. What you can do is when you move, you can take your estate planning documents to an attorney in that new state and show them what you have set up and ask them whether or not there's something in the new state that you could take advantage of. So for example, if you're moving from New York to California, California being a community property state has different rules regarding assets, and you may want to do a different type of estate plan, especially if you're married, to encompass what those rules are in California. And a lot of times what will happen is you will meet with that local attorney who will say the estate plan documents are fine, but let's update your healthcare directive, let's update your power of attorney to a local form for that particular state, because they're often just state-based forms that are easy to fill out, and they're easier for the local banks and the local doctors to use because they've seen them before and they aren't concerned about what this out-of-state form says. And question 5, can I create a trust for my life insurance policy for my child? And the answer is yes, absolutely. If that child is under the age of 18, it's a good idea to have a trust so that if you die before they're 18 and that money gets distributed, we have a trustee set up who can manage that money for the child until they reach the age of 18 or maybe a later time. So let's say you have a $5 million life insurance policy and you don't want your 18-year-old to get all $5 million the day they turn 18 and head off to college. So what you can do is have the trust manage that money. They can manage the $5 million, let's say give them some money while they're in college, and then use the rest for things like a wedding, buying a first home, starting a business. So we can use that trust to be able to protect and manage that legacy for your kids without them just suddenly getting millions of dollars when they turn the age of 18. So those are our 5 questions for the week. If you like this video, you can hit the like or the thumbs up button below. You can subscribe to future episodes on YouTube. You can find it at ayerslawtv.com. Below in the link, there'll also be where you can submit a question for future episodes. You can always go to andrewmayers.com. We can set up a legal strategy session. For more information, we can discuss any of these questions. Wherever you are, I hope you have a wonderful weekend.